I think we'll start that over again.
He caught me off guard too.
59,
Who was that dashing fellow
59,
in the
15.
title?
Child Protection in Iowa is brought to you by Vocal Victims of Child Abuse Laws. You can watch our program on Sunday afternoon. This is Des Moines time at 1 o'clock. Wednesday evening at 9:30 on Mediacom Cable Channel 15. If there's other stations airing this program, it no doubt will be on another time. You can email us at vocaliowa@mchsi.com. My telephone number is 515-276-3956. John's number is 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. That's Child Protection in Iowa. There's a number of things that we do in this business of public policy with respect to child protection. That is to attempt, first of all, to influence the public policy regarding child protection. And secondly, this is more of a hands-on chore of ours, and that is to assist people who are having difficulties with the Department of Human Services and the juvenile court with respect to removal of children and with all kinds of things that tend to discourage good family relationships. Well, we've seen quite a bit of things happening in the state legislature, and I'll be having, provided we have sufficient time in our program, having two videotapes. One is a videotape that of a group that is assembled to review what happens in this child abuse area. It's called a citizen review a group, and it's supposed to be watching over what's happening, particularly in the area of foster care and this sort of thing. Well, that group is headed by a fellow by the name of Jerry Foxhoven. And then we'll also have a time of looking at the council for the Department of Human Services. They are appointed by the governor, by the governor's office, and they are the ones who are to have oversight of the policies for the Department of Human Services. Well, that's a pretty large organization altogether, Department of Human Services. A number of departments and bureaus and chapters and everything else within that department, and loads of money. From the two videotapes, we'll be hearing something called legislative updates. Legislative updates is an opportunity for these people to sort of pat themselves on the back for how successful they've been in getting in and getting all kinds of funding from the state legislature. State legislature, the General Assembly, has been somewhat poor as far as its ability to supply funds for very important projects, but for some reason it seems as though some people are able to maximize those gifts to their agency and to their pet projects. And it seems as though there's been a real struggle between the House and the Senate. It appears as though the Senate wants to push up the amount of spending. Something right now, as we are taping this, that they're about $25 million apart between the House and the Senate with respect to their proposals, and they were supposed to have gone home a week ago. So it looks as though at the time of taping here that they're going to be in business for quite some time. Well, that gives you kind of an idea of what we're going to see on today's program. Those two tapes, one of the CAPTA, that's the Citizens Review, and the other one is the story regarding council, the DHS council. The council meeting was videotaped on the same day that this program was taped. One of them was done early in the morning, and one of them was taped late in the afternoon. So that's about as fresh information as we can get on cable television. Well, let's take a look at what is happening also along the court scene. And to do that, we call in a fellow by the name of Terence Walker. Let's see if he's in his office over there. Terence Walker.
Well, thanks for having me on once again, John. And appreciate being on the show. And I appreciate being the only person that I know of here in the United States is sharing this information on a constant basis on the judiciary. Something that's much needed, that needs to be talked about, and I think that the topic is ripe for discussion. One of the things, it's kind of a collateral issue here. One of the things I wanted to talk about here real quick. We all know that on the show we discuss children and DHS and removal of homes and termination of parent rights and things of that nature. One article that I wanted to discuss comes around that tangentially relates to the courts. Even though Congress enacted the provisions, the courts enforces or interprets these provisions quite a lot here. This comes from Phyllis Schlafly. She wrote a book called The Supremacists about the tyranny of justices and judges and what to do about them. This is a May 9th article, which she wrote on her weblog. Federal incentives exist to make children fatherless. This is something that really needs to be touched upon because it's very sad that we've got a government that is basically given incentives from the federal government, or state governments given incentives from the federal government, which we pay federal income taxes to, basically to make children fatherless or motherless. And this is horrible. But 1984, and I'll just paraphrase this article, it's rather long. Congress passed a Child Support Enforcement Amendment, and it requires states to adopt voluntary guidelines for child support payments. And then in 1988, they passed the Family Support Act, which made the guidelines mandatory and gave the states 1 year to comply. And the Department of Health and Human Services consultant, who was president of what was termed later to be one of the largest private collection companies, which makes a profits on the onerous guidelines that create arrearages. The 1988 law extended to all child support orders. And what it does is it creates creates an expansion of federal control over private lives and uses a federal case registry to exercise surveillance over 19 million citizens, whether or not they are behind in child support payments. And the really troubling part of this legislation, which is still enacted, is that it used to be in the old days that the mothers or the fathers without the parent would basically have to resort on AFDC, basically public assistance, if they didn't have enough money to care for their children. Well, what they were trying to do in this legislation was to basically require parents to pay into this big collection agency and hold on to the money, and they do that, and they give the states incentives to collect more child support, and they do so at the detriment to the children. And states, according to this legislation, according to this article, states collect the child support money and deposit it in a state fund, and the federal government pays most of the administrative costs and dictates the way the system operates through mandates and financial incentives. The federal government pays 66% of the state's administrative overhead costs, 80% of the computer and technology enhancement costs, and 90% of the DNA testing for paternity. In addition, the states share in nearly a $500 million incentive reward pool based on whatever the state collects. And the states can get a waiver to spend this bonus money any way they choose. So you have states going after $500 million on a yearly basis, and it's just insane. And they do so, like I say, to the detriment of the child. And most of the child support owed by welfare class fathers is uncollectible. So in order to cash in on federal bonus money, the states began bringing into the government system middle-class fathers with jobs who were never on welfare. These non-welfare families have grown to represent 83% of the child support cases and 92% of the money collected, creating a windfall of federal money flowing to the states. And what's the end all of all of this? What happens when they collect all this money? The states, since they're given all these powerful incentives, they go out and collect all these monies and issue levies and garner wages and whatnot. And what happens is, do the mothers or the fatherless or the motherless child, do they get money from their deadbeat dad or deadbeat mother? No. Sometimes it doesn't come into their pockets, rather. What happens sometimes is that the states tend to hang on to the father's payments as long as possible before paying it out to the mothers. And the General Accounting Office reported that in 2002 that states were holding on to $657 million in undistributed child support. Fatherless boys are 60% more likely to run away, 37% more likely to abuse drugs. Fatherless girls are twice as likely to get pregnant and 53% more likely to commit suicide. Fatherless boys and girls are twice as likely to drop out of high school and twice as likely to end up in jail. And, we can no longer ignore how this taxpayer money that we are all providing is creating incentives for state government agency to wreak havoc on the American family. And that's too bad that this system is like this. I think it's time for a change. Do you have any comments, John or Don?
You were referring to fatherless.
Well, fatherless is what she said. She quoted that there's motherless. I guess the assumption in a lot of the state legislatures' language is fatherless when they refer to these children. But, I'm a single parent, so I've got a motherless, basically, son. So it doesn't always fit. They should use a more gender neutral language. I think I was just reading off of the article, which is why I said that.
But I was wanting to emphasize what you were just saying there, talking about fatherless, or as you brought up the word motherless, that that's a key deal.
Yeah, it is.
If where the state removes the father or the mother or both, there's going to be disaster. No matter
Exactly.
how you look at it. God didn't create a family without the father and mother. He didn't create the state to be the parents. Okay, John, you got a comment.
Sure do. It seems as though our public policy doesn't follow common sense. And I think that's what you were touching on here, Don. It's common sense that we have mother, father, Jane and Dick, and Spot and Puff. That is what we have always known as a nuclear family. And to tear any segment of that family apart from the others is to do real damage. So what do? We find a system called foster care. Foster care is a place to put children when we want to destroy the family and we need a parking place for the ones who are still living, the ones who haven't been so badly damaged that we have to institutionalize them. We are doing some major damage when we dream up things like foster care. So in Iowa, I know that at one point they were spending something like $72 million in foster care. Now that's just for Iowa, the land, the glorious land between the rivers. $72 million. Well, $72 million is a significant piece of change when they start talking about it in the state legislature. That's money that could be better spent on other things, or it could be returned to the taxpayers who furnished it in the first place. If the concept of taking children away from parents and putting them in foster care so that the influence of the department can be better served, so that their rigorous techniques in straightening everything out can be fully observed, then our public policy is anti-family. Not only is it anti-family, but it is anti-pocketbook because it costs big bucks to tear the families apart and pretend that we're putting them back together again.
And I think that the other problem I had with this, and that's why I brought it up, was that, every time I see the Court of Appeals files a bunch of opinions, Court of Appeals here in Iowa, there's usually 10 to 15 or even 20 termination of parental rights cases. And this is just, it's horrible. But yet, and a lot of times it's done because supposedly the absent parent isn't providing for the child, so they terminate the rights, and so guess what? They have this huge financial burden that's going back on all of us once again. So it's just a big cycle of insanity, which these policymakers are actually implementing, and to the detriment not only of all of us as taxpayers, but all of our families as well.
That's rather interesting, because anytime you make an incentive, you develop some kind of a program for the state agencies to follow. They'll follow that program so long as you fill their pockets. And that $72 million, of course, is a nice sum of money to get your hands on. So you'll do whatever it takes, even if it means stealing children. Of course, they have to go to the rule book and to change the laws so that they can make child stealing legal for the industry. I'll have to say that in this General Assembly, if I understand at least one of the bills, says that we're not going to do that in every case. We're not going to take every case to court and to make certain that there is a judge supervising all these things. We are arranging for some families, particularly with handicapped children or children with major physical or mental difficulties, to gain some access to the bureaucracy without having to go through the courts. And if that is as clear, and if that is as I understand it so far, I must applaud those who stood behind the idea of skipping the courts. However, I suspicion that when you skip the supervision of the courts, you may be skipping some of the accountability that the courts require, because there's nobody there to watch how the money is spent, or to keep track or report how that money is spent. So there's a possibility they'll be spending that money wildly and saying, this is what we did for this family, this is what we did for this family, and we didn't take them to court. On the positive side, it cuts down on what we call the docket. We are a litigious society, and it seems as though everything we do has to go to court first, as if the court was some magical technique for finding what is right and what is equitable. So any opportunity we have to lessen the docket, I must applaud that kind of effort, because we don't need more litigation. We need some common sense pumped into the system somehow. And there must be some reasonable minds at work here. At least that's what I'm thinking at this point. We've got common sense disconnected from public policy, and whenever you have that kind of a situation, it can only lead to chaos. And what you've been reading there tells a little bit about chaos. And I learned something from Shafley's article there, because I saw a lot of money coming into the system, this child support recovery and foster care recovery, and I couldn't figure out how it is that they can hire FTE after FTE, that's full-time equivalent, employee. I didn't realize that the government was actually sponsoring this attack.
It's what you could call a war on children.
That's right.
Skip the war on terrorism. It's the war on children.
That's right.
And I would you finish, or I was going to move on to another article here. One other court case that I wanted to bring to you guys' attention here, the HSLDA, which you are familiar with. I can't remember the acronym.
Home School Legal Defense Association.
That's what I was thinking, but I didn't want to mess it up here. Homeschool Legal Defense Association has a case. They had a case rather that was that they were taken upon for a fellow by the name of George Thice. And the case began out in 1999 when the Department of Veteran Affairs denied benefits to homeschooling veteran George Thice on the ground that homeschooling does not qualify as an educational institution. According to Veteran Administration rules, when an eligible veteran has children, he or she may receive additional benefits until that child turns 22, if the child remains in full-time enrollment in an educational institution. In May of 1998, the General Counsel for the Veterans Administration reasoned that children who are being homeschooled cannot be considered to attend an educational institution because the word institution suggests an ongoing organization that exists to benefit numerous children, not just one individual. Well, to make a long story short, they basically denied Mr. Thice's benefits. So Mr. Thice brought this to appeal in front of the United States Court of Appeals for Veteran Claims, 2001. Then in 2003, uh, the attorney for the HSLDA argued in that court on behalf of Mr. Theis that the subsequent ruling. I'm sorry. He argued basically that the rule was unfair. To categorize one institution as uh, as fitting into the mold for being eligible for benefits and another one not. Well, the court subsequently made a ruling on July of 2004, reversed the Board of Veteran Affairs ruling, and in their language, they said that the court not only criticized the General Counsel for its narrow definition of the educational institution, but also its failure to present a rational, comprehensive explanation for not considering homeschooling to be an educational institution. And they basically just dropped the appeal, which is why this story comes to light just lately. They had fought this opinion. The VA had fought this opinion, but they decided to drop their appeal. But I found the words interesting: a rational, comprehensive explanation. Isn't that what we're lacking in a lot of our legal opinions
Right,
these days?
right.
A rational, comprehensive opinion. There was an opinion that issued in a case not too long ago, which escaped a rational, comprehensive opinion. That case was in front of the Iowa Court of Appeals, and I think the case was summarized best by Judge Sackett of the Court of Appeals, who said that in this case, this was April 28, 2005 case, 03-1224, Isidro Ramirez. He was fighting a murder conviction, and he was bringing it on post-conviction relief, which is a collateral appeal. But I think she summed it up best, is that when she said that this was in response to the prosecutor drawing up a order for the judge and having the judge sign it, and she basically states that the district court's decision to have the prosecutor draft the written ruling deprives me of the judgment that the district court exercised in signing the ruling. It also impacted on Ramirez's right to a fair trial and gives the appearance of unfairness. I recognize the district court did dictate a ruling in the record, but I do not believe that this should relieve the district court of preparing its own ruling. And what is even more troublesome is that the ruling prepared by the prosecutor contained factual and legal errors. So this is what we have come to here in Iowa and the United States. Instead of something that has a rational, comprehensive explanation, we have succumbed to having officials dictate rulings for other officials which contain factual and legal errors, and that suffices. That's insanity, and that's why with Vote Iowa Judges Out, the organization that I'm ahead of, we are advocating that we vote these despotic judges out of office because they are not obviously doing their job. And on that note, I had a email from Jacob Brzezinski here, with the president of the A Matter of Justice, which is online at www.amatterofjustice.org. He wrote on Saturday he saw the C-SPAN a portion of an event from the University of Missouri Law School. This was, I believe, Saturday. What was this past Saturday? Was it the 7th of May? It included a speech by Judge Colleen McMahon of the U.S. District Court in White Plains, New York. The judge was extraordinarily frank during most of her presentation. Albeit diplomatically, she blasted the federal judiciary for dishonesty, perversion of law, activism, arrogance, and even heartlessness. She said that no matter what their political stripes, gender, sexual orientation, etc., whenever they become federal district judges, she distinguished in this regard the appellate judiciary, they quickly begin to act as institutional creatures. The judge had little good to say about the federal appellate judges, saying that in most cases they affirm the trial court decisions no matter how wrong, with little review. She said that in those cases where there is actual appellate review, the appellate judges take positions more in line with their political prejudice than by interpreting the law. The conclusion of the speech was bizarre. The judge said something to the effect that when federal judges put on their robes, most rise to the occasion and do their best. Go figure that, says Jacob Brzezinski. So isn't that a twist of logic? They're dishonest, they pervert the law, they're activists, arrogance, and even heartlessness. Yet, when they put on their robes, most rise to the occasion and do their best. These are kind of things that are typical of what George Orwell would say is doublespeak. And I think that 2005 we've reached the point of what George Orwell called 1984. And I would add to that also this is not just in the federal judiciary. This is also in the Iowa judiciary. When we have a case such as this, which is less than 2 weeks ago, where the chief judge of the Iowa Court of Appeals is actually stating that the judge is basically signing off on a written order prepared by a prosecutor which contained factual and legal errors, and the guy's conviction is basically rubber stamp anyway, then it's a sad day in Iowa as well. And we've got the same despotic judges that twist the law here in Iowa as we do in the federal judiciary. Did you have comments on that, John or Don?
Yes, I've seen orders like that where I mentioned on last week's program where a judge actually created the facts that were necessary for conviction. He didn't look at the record to see if the facts were there. He actually dreamed them up, Alice in Wonderland style.
Are we talking about racetrack Novak?
That's correct.
Okay. I was just trying to make that clear.
You bet. Okay. Okay.
And for those of you that have missed out, Judge Novak, Polk County judge here, frequently attends the Prairie Meadows racetrack. When he sees a familiar face, he tries to dodge him. So, if you ever been, matter of fact, I believe it was my uncle that was in jury duty in front of him, and he tries to dodge him too. So, the funny thing is that we are gambling on justice when we have a guy like that in the courtroom, and he can manufacture facts. What he needs to do is manufacture a way to win out there on the racetrack, so he can kick the habit, or maybe it's a habit that's hard to kick. I don't know. Interesting. We also have Judge Arthur Gamble. I don't know if does he go out there? I think you said something about that last week.
No, I think you asked who I thought you had seen out there, Judge, and you said it was one of my favorite judges, and I said Gamble, because it fits with the racetrack.
I think racetrack Novak fits quite well too.
That's right. That's right. Well, turning to another subject here, not all that far off. There are a number of people who like to look at child advocacy and saying, when a child says he's been sexually abused, believe them. And Don is going to tell us a story later on. I trust we'll have enough time after this initial video of a girl who didn't tell the truth. This was a Fairfield girl. We have another case where a child in a Centerville school. In fact, they had built up 40 charges against the teacher in Centerville, and were not able to come up with a single charge or single charge that a jury would believe to convict this man, this teacher. The teacher has now resigned. I'd love to have him on the program to talk to him about some of these issues, because I think that the public should know that children do not always tell the truth. And I think that we have public policy that has now been built in such a way that a 3-year-old can scream out when Grandpa is rocking her in the chair and scream out that she's been sexually abused. This is because we have all of these programs that awaken a spirit in children that should never be awakened. That doesn't mean that children shouldn't have an active part in protecting themselves. But here was a little girl who was rocked by her grandfather and screamed out that she was being sexually abused, and Grandma came in, and Grandpa was somewhat shaken by this thing. Well, if children 2 and 3 years old can dream up a story, don't you suppose that other children, for other reasons, can dream up a story? I know of one lady at a little college here in Iowa decided that she wanted a new car, and she told her father that she needed that new car, and if she didn't get the new car, she was going to expose him for sexually abusing her. Well, he bought her the new car. Another girl tried the same thing, and the father didn't have the money for a new car, nor did he have the money to defend himself from a false allegation. But you see, public policy has made it possible for these kinds of devious things to occur and to make them appear to be true. And I think it's a crying shame. Well, let's take a quick listen to at least one tape here that tells us about the update in the legislature as it relates to child abuse, because the agency is very pleased about its success in the state legislature this time around. There are some things that need to be done in addition, but there are some successes that they can brag about. The person that you'll be hearing from here initially is a fellow by the name of Jerry Foxhoven, who is a child advocate and probably one of the finest people that you'll find working in this area. Bureaucrat, but still a decent fellow. Lawyer, but still a decent fellow. And I think that you'll enjoy listening to Jerry Foxhoven. Let's tune to his organization, which is a citizen review of CAPTA. That's the Child Abuse Prevention and Treatment Act. It's required that they comply with the citizen review requirement. Here now, Jerry Foxhoven.
Well, if you've all been reading the newspaper, you know that they're not home yet, and it doesn't look like they're going to be going home for a while, although we could be surprised, but I will be real surprised if they go home this week. I think they're going to be here for a while. I think one of the things we did see that was maybe a pleasant surprise was the substantial increase in funding for the Child Protective Center. I think there was originally some hope that it might be increased somewhat, and it was, I think, triple the funding. So it's a real positive. Now, that was in the Senate, of course.
Senate, right.
And it
I was just going to say,
it does have to go back to the House, and the House has certainly made pretty clear that they are concerned about the amount of spending that's in the budget. And so whether that good news will continue, I'm not sure, but at least that's where we're at for the meantime. And in terms, does anybody have any other legislation they're concerned about or anything on child protection?
I didn't give an update on Holmes.
It does look like Hope's is back alive.
But they're still looking at half that money going to empowerment.
Right.
Yeah.
So half it would be controlled by empowerment, and so I'm not quite sure. And again, who knows? As it goes back and forth between the two bodies, what's gonna be and how it's gonna be. I think there was this, and there's this bill that's primarily, I think, with delinquency, Ray, that was in the judicial budget, you know, that $100,000 for Polk County.
Yeah, I saw that. I didn't know what that was for.
But it came back, Hatch put it in the Senate, and the House passed it yesterday and took it back out. So it goes back to the Senate. And so, I don't know where that's going, if that's gonna go somewhere or not.
Do you know what agency that's targeted for?
Not at all. Not at all. It's $100,000 for some kind of youth initiative, and I don't know if it was for minority youth or what. It was pretty clear it was for delinquents and older ones. You know, I think
Yeah,
the 16.
16 to 22.
Yes.
Yeah, I saw that and sent it off to Fred Gay in our office because he does the youthful offender program. I was thinking maybe it was targeted, you know, for youthful offenders.
And it was specifically earmarked for Polk County.
Yeah.
So I'm not quite sure. You might want to
It may
get a
be
hold of
something-
Senator Hatch, because I think that's who had proposed it. So he,
Yeah, it may be something for that youthful offender program that we run through the Department of Corrections here,
could be.
but I don't know.
But I think that's up in the air again, because the House passed it yesterday without it. They struck that, they added an amendment to it, that struck that provision. And so,
I think the money for the 5 mediation projects was in the Senate version. I don't know whether they did anything with that yesterday or not, but it passed the Senate. Same amount of funding as there was last year, $148,000 to be divided among 4 or 5 projects. So that, and Jerry helped on that, helped us get that back in. So those look like they're safe, I think, for another year. I don't know where those projects are. We have one.
I don't know where else they are either. I think, and I don't know if they've changed the dynamics elsewhere, but I think Polk County was the only front end one, wasn't it? At least at one point, it was the
Yeah.
only front end one. And that's why I was so fired up about the Polk County one. It's at the front end instead of at the back end. And I think it's had just incredible results, you know, in terms of keeping families together, keeping them out of court, giving them options to fix problems without being involved in the court.
Yeah, and, you know, that was before the new redesign kicked in. Last year, we filed 722 China cases here in Polk County under the old system, which was down from a high in 2001, I think, before we started doing mediation. We had 11 or 1,200. So it'll be interesting to see under the redesign how many cases we file in the corresponding 12 months and do a little comparison. But we're not sending as many cases to mediation as we did under the old system, and that's a department choice. But again, we'll see how they're going. They're sending those cases instead of to mediation, they're going to family care, community care. We'll see how many of them recycle, how many of them we get back.
Yeah, and
Community
for those of
care
you
is
that-
costing
if
our
you remember,
state
the
$1
community
million
care has
a year.
really no
It's an experimental
mechanism
program.
to ensure that people
No
will
one
go
seems to
and
know
follow
much
through.
about it.
The mediation project in Polk County's mechanism is if you don't, we file. And so they are able to monitor, compliance monitor, the families are getting help. And so it's been really, I think their numbers have been pretty staggering in terms of success rates that, you know, families who have said, yeah, I don't want the courts in our lives, and we are willing to make these changes and follow through, and it's been really incredible, very small percentage.
Well, actually, they did a study of our numbers, the families that we put in there, and they compared them to families that were referred to other services or went to court, and success rate was virtually the same. That we were having as much success dealing with those people.
This
outside.
is Ray Blaze. He's with the juvenile court
Not only do we see the costs,
here in Polk County.
but we also, again, get keep the courts out of people's lives.
Yeah.
Let them fix their own problems. I mean, give them some help doing it, and some kind of, a little bit of holding something over their head to make sure they do, but,
The carrot and the stick.
yeah, very much so, but it has been just very, very successful. So hopefully that will be able to continue. Hope the House doesn't strip it out of there.
Do you know much about what was in the paper today about the money from the meth bill being funneled over to the sex offender?
I don't know where that's gonna go. I mean, there are two bills that the legislature has really set really pretty high priorities on. And those bills are passing, those bills are getting signed. It's the funding of them that's gonna be the issue, you know? And I'm not quite sure where that's gonna go from there. I don't think there's any question the two houses are gonna have to get together in some conference committees and try to iron out a solution to them. Because right now, they're worlds apart, you know?
Maybe we can provide them a mediator.
Yeah. I do think there's some, you know, there's some hope, because if you look at the Speaker of the House's statements, while he said he's digging in on the cigarette tax and all those things, he does keep tying it to, unless we get our 4 priorities, we're not gonna agree with that tax cut, which I think at least opens the door to negotiations on some of those issues that they wanted. One was some property tax reform and some things like that. And so I think that while in many terms it sounds like he's taking a very hard line, there certainly seems to be making it clear he's opening a door at least for them to sit down and talk. And so.
But I think what they cut out of that meth bill was corrections part of it. They
Monitoring, I think.
Yeah, they had pledged in the budget process that they were gonna fund some corrections workers, and they were gonna pay for some substance abuse evaluations for people who are arrested pre-trial, released from jail. They were gonna have conditions, and they were gonna be monitored.
Well, that'll give you some kind of an idea about some of the subjects that are being talked about in the General Assembly, and of course being reflected by these individuals who are serving on the review committee. It seems as though the same people who are running the show here are the ones who are doing the reviews, and one would think that you would have in a citizen review situation that you would have citizens, but the people that are sitting around the table are not what you would generally think of as everyday citizens. Well, earlier in the program I mentioned that Don was going to talk about a case in Fairfield, Iowa, where a child brought forth some statements. We can't say the statements are false, but we can certainly say that the statements that were brought against her father have not been satisfactorily proven in a court of law. And this is the case of Lawrence Smith of Fairfield, Iowa. Tell us about Lawrence Smith, Don.
You mentioned a child making statements and not necessarily being false. I look at it also as the fact that adults have a way of influencing children. Sometimes adults never grow up. Anyway, aside from that, I'll read you the Des Moines Register article on Judge Declares Mistrial in Abuse Case, published April 19th of this year. Jurors, after deliberating for more than 7 hours, couldn't agree in the retrial of a man accused of incest. The second trial of a Fairfield insurance agent accused of sexually abusing his daughter ended in a mistrial Monday. Larry Smith, Jr. was accused of 20 counts of incest and 7 counts of third-degree sexual abuse. Prosecutors alleged that Smith forced his daughter, now 19, to have sex with him beginning when she was 12. So now she's 19 and she's making these comments. Makes me wonder if there's some adults in her life that are encouraging her along this line. Maybe some kind of a motivation for her to do that, aside from fact that well, anyway, I'll continue on.
By the
here.
way, there was no forensic evidence of any sort in support of the child's claims.
So the issue should be dropped if there's no truth to it, no facts to back it up anyway.
Right.
Last fall, a mistrial occurred when a jury was unable to reach a decision after deliberating 9 hours. The most recent mistrial was declared when the jury remained deadlocked after more than 7 hours of deliberation Friday afternoon and Monday morning. Afterward, juror Joseph Kessler of Brigton declined to comment, saying the 10 men and 2 women who made up the jury had agreed not to speak to the media. In downtown Fairfield, community members showed surprise that the trial had again ended in a hung jury. Several said they were doubtful that concrete answers would ever be found. Just from reading it, quote, just from reading it, I would have never wanted to be on that jury, unquote, said Mary Hollingsworth, who worked at the local cleaners. Quote, you want to believe one story, and then you want to believe another. There are so many things that don't make sense, unquote. Smith's daughter, who declined to be identified, testified last week that the abuse occurred early in the morning when her mother and brother were sleeping. Smith denied the allegations, saying both of his children opted to live with him after he and his wife divorced 2 years ago. So look at that. They have a divorce. The daughter is living in his home. The daughter chose to live in the home. And then after a few more years go by and the ex moves out of the house, then these accusations come up. It's gives a case to wonder there why the accusations are coming up now when there was none before. Smith was unavailable to comment. His Fairfield business was closed Monday, and no one answered the telephone. His attorney, Stephen Gardner of Ottumwa, declined to comment. Jefferson County Attorney Tim Dill said he was not surprised by the jury's outcome. It wasn't as big of a shock because it is a tough case, and people have different opinions, Dill said. Dill said that the possibility of another trial depends on discussions with family members, and that a change of venue is possible. There's pros and cons, Dill said. There's certainly people that know his history in the community, and the people that don't. There's people that know him as an upstanding community person. It worked both ways. Smith's daughter and son currently live with their mother, Smith's ex-wife, in Fairfield. Jeff Sims, a painter from Fairfield, said trying to prosecute Smith for the third time is a waste of time and taxpayers' money. Quote, if you send someone through trial twice and you can't convict them, it's time to give up. Well, I got another thought. If a person goes through court twice and is not convicted, and then the third time he's convicted, is he guilty? 2 times people's jurors, now that's 24 jurors, have ruled that he's innocent. Now 12 ruled that he's guilty. Well,
That's right.
is he?
That's
John?
right. Okay, let's move quickly now to the council room, where we'll hear another legislative update. A few minutes of update by someone who is paid as a lobbyist to the Department of Human Services. Let's go now to DHS. This is actually a phone conference of the Council for the Department of Human Services.
Everyone, I want to apologize for being a few minutes late. I was at a breakfast meeting over at the Drake Diner, and the weather made the traffic an unexpected obstacle to getting here on time, so I do apologize.
Understandable.
Probably the first question you all would ask me is, when are they ever going to get done? Which is the question of the hour that I have no answer to and won't even try to give you an answer to. Yesterday I heard talk of, oh, they'll be done by the end of the next week, and then I also heard, what are we going to do? The state doesn't have any provisions for continuing budget resolutions, and the fiscal year begins July 1st. So
Gary?
I don't, I can't think it will come to that, but there are no answers to how long it's going to take. The Senate has passed their compromise budget and has sent it to the sent some of the budget bills to the House, and the House does not agree with the compromise that the Senate made. And I think that my understanding is they're about $25 million apart, predominantly on education and in the human services budget are the two areas where those dollars are the most significant. Probably the next question you'd ask me is what bills are outstanding for the department. The major piece of legislation impacting this agency that's outstanding is the budget. And I think there's pretty universal agreement that our budget bill, House File 825, will be the last one of the last ones to be acted upon. I think there's also a real risk that our budget bill could go, and along with many others, could go to a conference committee. In my 5 legislative sessions, I have dealt with one conference committee. It was on a fairly minor piece of legislation, and everyone had agreed to the amendment before they walked in the room. So the conference committee took about 10 minutes, and it was over. So my experience with them is extremely limited, but as I understand it, the meetings are public and conducted similar to a budget subcommittee meeting. Conferees are appointed. Then the House and the Senate has the option to either agree to the conferee's amendment or not, but they cannot amend a conferee's decision or a conference committee's decision. The Senate included a number of items in the budget bill that were very pleasing to the department, particularly in the area of child welfare. There were a number of items around the child welfare redesign, $3.3 million to be exact, that were terrific. Some money for the flexible funding pool for field staff, some money for family team meetings expansion, a little bit of money for shelter care to increase the bed capacity, and some money for the child protection centers and community partnerships. There was some money for DCAT.
The family team
so
meetings is a
we are
newer
hopeful
concept
that as the
being
House
worked
and
on,
Senate begin their
developed
compromise on the
actually
budget,
originally
those
in
items
Cedar
will
Rapids.
stay in the budget. The budget really is in pretty good shape. The salary bill is funded at, I think, 90% by the Senate. It was funded at 80% by the House. The best salary bill I've ever seen. So that's where we are in the budget. The other big piece of news from this week is that on Monday the House agreed to the Senate amendment on House File 841, which is the Medicaid reform bill, and that bill will be signed by the governor tomorrow. Very exciting. We made it through that process. There were 9 no votes in the Senate. There was 1 no vote in the House. A lot of work, a lot of subcommittee work, a lot of public input. It was just a very exciting process to be a part of. And now, the agency's focus shifts to implementation. So that'll continue the interest in this piece of legislation and how it plays out, and it's certainly being watched nationally. Another piece of legislation that's still outstanding for the department is the MHDD Commission bill. That bill underwent several amendments in the House, was sent to the Senate where it is currently languishing in Ways and Means Committee. I think it faces an uncertain future. I don't think it's all the way over yet, but I don't feel terribly positive about that bill going to final passage either. Apart from that, all the rest of our Department of Human Services bills have passed, and I think they may have all even been signed by the governor now. The governor signed the custody relinquishment bill last week.
Mental health parity.
Mental health parity has been signed. The DCAT bill, the 812 bill. I think they've all been signed. So that is a nice bit of success to have this session when I had my doubts when we started that if we were going to bring 8 bills to the legislature.
Well, you've been listening to a portion of the presentation of legislative update to the DHS Council. Thank you for tuning in. We'll see you next week.